Thank you for asking me to appear. In roughly 2005, we spent a year in my office on an initiative on end-of-life care, and we decidedly kept death with dignity, physician-assisted suicide outside the considerations of that initiative, not because not an important public policy issue, but rather there were many issues that we felt should be addressed with durable powers of attorney and living wills and the like, a statewide registry of saying that, in our view, if we tried to confront the death with dignity issue, that the rest of what we were trying to accomplish might not get accomplished because of the nature of the strongly felt views on both sides of this issue. And we were successful with that initiative and a number of legislative and regulatory changes that flowed from that. But it's time to address this issue. And Vermont has a long and proud history of not being afraid to either lead the nation or be close to leading the nation on issues that relate to civil rights, personal rights, and personal privacy. I think the right to make an informed decision about the end of your life when you are terminally ill and you have all your faculties about you, the option to be able to make that choice is a civil right. I think it's a personal right. I think it's a hugely private right. And there are people I respect who oppose people having this opportunity, and they're entitled to those opinions. But I think it's important to emphasize some of the things that this bill is not. This is not a bill that encourages people to abbreviate their lives. This is not an out for those who, due to depression or conditions in their life, just want it to all stop. These are for Vermonters who are terminally ill, who have the prognosis from more than one physician that they're going to die and that they're likely to die within 6 months. This is a bill that, if adopted into law, empowers people to make informed choices. And there are many, many protections in this bill to avoid undue influence on Vermonters in making this most personal of decisions. And perhaps this is a situation where it's good that Vermont isn't the first in the nation to consider legislation of this type, but we have 2 states that, in Oregon's case for going on 15 years now, have experiences with this type of program. And I'm sure during the rest of this week or in coming weeks you'll hear from folks from Oregon who talk about their actual experiences and what has happened and what has not happened. I'm convinced that there are no legal impediments, at least currently, to your enacting this legislation. I think there are very real safeguards that are in the proposal to make sure and double sure that these are informed choices by individuals who are terminally ill and have the mental functioning ability to make informed choices. And just to follow up somewhat on Governor Punen's testimony, she talked about one former state senator who recently passed away. I have another former state senator, the late great Esther Sorrell, served 10 years in this chamber. And although a devout Catholic, she respected women's right to choose, and I'm virtually certain that despite her absolute zest for life, that if she was in this body today, she would be supportive of this legislation.